All right, everyone. I just wanted to pick up and go a little bit further here tonight, and I'm doing this lecture at around 11 p.m. on Wednesday evening. So I really hope that you are watching these because I'm putting in some time to make sure that you have this information and hopefully deepen your understandings of how the law works and how it applies to our course. So I wanted to start tonight with the case of Gideon v. Wainwright. It's on your must-know Supreme Court cases, and it actually is a pretty wonderful story. Without going too deep down the rabbit hole, we'll just say that Clarence Earl Gideon was arrested for burglary one evening or early morning in the state of Florida. And so, prior to the Gideon case, right, defendants were allowed or were appointed attorneys in any federal case because they had long since established in the law that the Fifth Amendment right, protection against self-incrimination, and the Sixth Amendment right to a fair trial work together. It's that in federal cases, a person was guaranteed a lawyer. But prior to the Gideon case, that kind of federal understanding had not been incorporated at the state level. So when Gideon was charged with burglary in Florida, he appeared before court, and the state judge basically said, "I'm sorry, under the state of Florida, we cannot give you a lawyer, and you must represent yourself." And so Gideon was found guilty, sentenced to 5 years in prison, and while in prison, this pretty poorly educated man, launched an appeal that went all the way to the Supreme Court, and eventually incorporated the right to counsel at the state level in any felony cases. Now, I already told you in the previous lecture that this was extended to eventually be any cases um, where threat of jail time was. But the question of does the Sixth Amendment's right to counsel in criminal cases extend to defendants in state courts was clearly settled in the Gideon v. Wainwright, and it is an incorporation case. Moving on. Another case with a pretty interesting story behind it that actually becomes hugely influential, less so for the Griswold decision, but for some of the decisions that came after Griswold and kind of used the legal reasoning of the Griswold majority decision. And so the story essentially was that in Connecticut in the 1960s, birth control was illegal, right? And so because it was illegal, married couples or single women or whoever were not allowed to receive advice from their doctors about contraception. And so the question, does the Constitution protect the right of privacy on a couple's ability to be counseled about, their options in terms of family planning? And so what the Griswold decision did was pretty monumental because if I were to ask you right now, does the Constitution of the United States provide legal protections for privacy? Your answer would probably be yes. But if you were to really look at the Constitution of the United States, you'd look for a long time and never see the word privacy. There is no, at least enumerated, constitutional right to privacy. But what the court did in the Griswold v. Connecticut decision was kind of use various civil liberty amendment, like various civil liberties together, various amendments together, and say that when you read the First Amendment, the Third Amendment, the Fourth Amendment, and the Ninth Amendment together, when you kind of layer all these, there is an implied constitutional right to privacy. Most easy to understand from that would be the fourth, right, which is protection against unreasonable search and seizures. And so, the court's using that in conjunction with other amendments to basically say that the government intruding into your life in any way constitutes a search or a seizure. And so, therefore, that is prohibited by the Constitution. And what the Griswold decision essentially did was create a constitutional right to privacy. Um, in general, but also specifically with regards to healthcare. And so, as a result of this, Connecticut's law banning contraception was thrown out. It was ruled unconstitutional pretty much immediately. And you can kind of see that the Griswold decision maybe has future implications as we get to its much more famous cousin case, which is Roe v. Wade. But moving right along. I talked about Miranda v. Arizona in the previous lecture, so I don't need to go too deep here. But this was another, um, basically another, what do you want to say, incorporation case. As the question was, do the Fifth Amendment's protection against self-incrimination extend to police interrogation of a suspect, particularly at the state level? Now, at the federal level, we'd already known that you were protected in federal courts from self incrimination, which is why you can plead the Fifth, right? You can invoke your Fifth Amendment rights, that you have the right not to provide evidence against yourself that would contribute to your guilt. That's the prosecution's job to prove you guilty. They can't make you do it for them. And so we that Fifth Amendment protection pretty much already existed um, at federal cases, but it was less clear at the state level. And so here we had this man who was picked up, and as I told you in the previous lecture, right, he was only, I think, a third grade education, very minimal knowledge of any sort of civil liberties or any rights that he had. And so, he was found guilty, and the ACLU interest groups basically launched a defense or an appeal on his behalf that basically said that by not informing Mr. Miranda of his constitutional rights to, like the Fifth Amendment protection against self-incrimination, by not informing him of the rights, they effectively denied him those rights. And so the case finding, the holding of Miranda v. Arizona was that the Fifth Amendment's protection against self-incrimination is available in all settings, at the state level, at the federal level, at the county level. And that if the prosecution is using statements that you made prior to being read your now known as Miranda rights, then anything you say after that could be thrown out and inadmissible in court. And so this gave rise not to the incorporating the Fifth Amendment at the state level, but also the very famous Miranda rights, which is you have the right to remain silent. Anything you say can and will be used against you in the court of law. You have the right to an attorney. If you cannot afford to hire an attorney, one will be appointed to you, right? These are very famous Miranda rights that came from Miranda v. Arizona, essentially an incorporation case of the Fifth Amendment. Another case I've also talked about in the lecture on civil rights and civil liberties was the Tinker case, Tinker v. Des Moines Independent School District. This was in 1969 at the height, the fever pitch of the Vietnam War era, right? And you had Mary Beth Tinker, and I don't know the male student counterpart. She's the much more famous of the duo. That decided that they were going to protest the Vietnam War by wearing a black armband to symbolically um, show their opposition to the war. And so they were asked to take it off. When they refused to take it off, they were sent home from the day and suspended and told you can't return to school until you agree to take off your black armband. And so they sued, and essentially the legal question was less about the armband than more about a freedom of speech case, a symbolic speech specifically, which is, does a prohibition, and the question is, does a prohibition against the wearing of armbands in school count as symbolic protest, and therefore basically violate your freedom of speech, right? Is symbolic speech? The court had said yes. And so if you're deprived of symbolic speech, are you being deprived of your First Amendment rights? And so the decision was a nuanced one as it relates to schools and it relates to symbolic speech. On the surface, the court said that yes, armbands or any sort of symbols or anything is symbolic speech, and therefore and it agrees as speech, and because it's speech, you have a freedom to do it, right? But as with all things, there are limits. And so while the court said that yes, Mary Beth Tinker and her male counterpart had the right to do that, we also want to nuance and basically say that in schools, if schools are going to suppress speech, meaning say you can't wear a t-shirt with a giant marijuana leaf on it or an AK-47, which we do, if schools are going to suppress that sort of symbolic speech, school officials must be able to basically make a very strong argument that allowing such speech would run counter to their ability to operate an orderly and safe school. And so that established sort of the Tinker test for when schools could limit freedom of speech. If speech severely interrupted or interfered with the daily operation of schools, then schools were allowed to limit the speech. But short of that, right, symbolic speech is speech and therefore it must be allowed. Next one is another First Amendment case. It's the Lemon v. Kurtzman case, another one dealing not with speech or expression, but instead it is a religion case, kind of in the same vein as the Engel v. Vitale case that I talked to you about earlier. And essentially, what this case sought to do was to kind of define the limits on what you could use federal funding for in religious institutions. And so the question essentially was, can a state government like Colorado issue taxpayer dollars to religious institutions such as a private religious school? Right? Can Colorado give money to St. Mary's High School? It's pretty clear that the Establishment Clause of the First Amendment says the government can't favor religion over non religion or any religion over any other religion. But can the state give money to a religious schools? I mean, on the surface, you would think absolutely not. But the court essentially found, as well, with a lot of different case rulings, that there's nuance that needs to be observed. And that basically, um, anytime that federal or public tax dollars is being used to fund religious institutions, that basically it cannot be used for religious purposes at all. So you couldn't use taxpayer dollars to hire a religion teacher. You couldn't use taxpayer dollars to purchase religious curriculum, to buy a big cross to hang in the lobby of the school. So you can't use public tax dollars for any religious purposes. You can't use that money to encourage or discourage religion. So you can't use it as a recruiting event or an outreach campaign for the church or religious school. And essentially, the only way that you could give money to a religious institution is if they were using that money to do basically a general good that was overtly non-religious. So, you could give money, the state of Colorado could give money to Catholic charities and use it for English language classes, like it does at Atlas High School on Wednesday evenings. That would be okay, even though it's a Catholic group. And so that's essentially become known as the lemon test, which is, does that pass the lemon test? Does giving this money pass the lemon test and clear the three hurdles that you see on the bottom left? Last case we'll talk about here tonight is another fairly familiar case that resonates within United States history classes and APUSH especially, which was dealing with the famous Pentagon Papers. The story of this is chronicled in the movie called The Post, which is really quite excellent, and I would highly recommend it for quarantine viewing. But the question is when the Nixon administration tried to prevent the publication by the New York Times of the Pentagon Papers, calling it classified information, were they violating the First Amendment, the freedom of press? Could they use higher restraint in order to do that? And so obviously the story, as you've now heard it many times, was that the court ultimately found in favor of the New York Times Company and basically said that the Nixon administration cannot prior restrain their publishing the papers. And because prior restraint of the Amendment rights cannot incur unless the government establishes that this would be inevitable, direct,